There is a number that the Canadian government has repeated with something close to pride over the past several months. Asylum claims are down 63% compared to 2024. In the language of administrative success, that number tells a clean story. A system that was overwhelmed has been brought under control. A backlog that was unmanageable has been reduced. A policy reform has worked exactly as intended. But a number like that describes a direction. It does not describe a destination. And a federal court filing submitted by the Canadian Council for Refugees and Amnesty International Canada in recent weeks tells you precisely where a meaningful share of that 63% actually went. Not back to safety, not to a fair hearing somewhere else. In specific, documented cases now sitting in a Canadian courtroom, that 63% went directly into the custody of United States Immigration and Customs Enforcement, into detention centers in Buffalo, under conditions that the people who experienced them are now testifying to in sworn legal documents. Most coverage of this story stopped at the statistic. The operational reality, contained in the court filing itself, goes considerably further. Over the next few minutes, I'm going to walk you through exactly what changed in Canadian law, how that change connects to an agreement most Canadians have never closely examined, and what happened to 4 specific people once the system did what it was redesigned to do. Here is what actually happened with the law first, because the legal architecture explains everything that follows. On March 26, 2026, the Carney government passed a piece of legislation called the Strengthening Canada's Immigration System and Borders Act, known in the legislative record as Bill C-12. The bill restructured Canada's asylum process in 3 specific ways, and each one matters individually before you see how they work together. First, it imposed a 1-year time limit on asylum applications, measured from the date of entry into Canada. Miss that window, and your claim is no longer evaluated by the Immigration and Refugee Board, the body that has historically handled asylum determinations with a structured, adversarial but fair process. Instead, you are routed into something called a pre-removal risk assessment, a process with a substantially higher rejection rate and considerably less procedural protection. Second, it imposed a 14-day limit on asylum claims made after crossing a land border. Claims filed after that window are not reviewed at all. They are closed administratively, which means the person making the claim never gets a hearing on the merits of their case. Third, and this is the provision that connects most directly to what happened in the documented cases, it expanded the authority of border security officials to share data across agencies and to suspend or cancel a person's documents administratively, without the kind of institutional review that previously slowed this kind of decision down. Each of these 3 changes, examined in isolation, sounds like routine immigration administration. Time limits exist in plenty of legal systems. Faster processing sounds, on its face, like an improvement over a backlogged system that leaves people waiting in uncertainty for years. That is the official framing the government has used consistently: modernization, efficiency, the prevention of abuse. The operational reality is that these 3 changes function together as a filtering mechanism, and the federal court filing argues that the mechanism is now operating in direct violation of constitutional guarantees. Now, hold all of that against the second piece of architecture in this story, because Bill C-12 does not operate alone. It operates inside the framework of the Safe Third Country Agreement, known as the STCA. A long-standing arrangement between Canada and the United States that designates the U.S. as a country where Canada can safely return asylum seekers who arrive at the Canadian border, on the premise that the United States itself provides a fair and adequate asylum process. The entire legal foundation of the STCA rests on that premise. The agreement only functions, constitutionally, if the United States actually is a safe place to be returned to. The court challenge filed by the Canadian Council for Refugees and Amnesty International argues, with specific documented cases, that this premise no longer holds. The filing alleges that Canadian border officials have been denying asylum seekers access to humanitarian exceptions that exist in law, denying access to legal counsel before handing people over, and transferring individuals directly into the custody of the Trump administration's deportation infrastructure, an infrastructure that has expanded substantially over the past 2 years, and that operates under standards considerably different from what existed when the STCA was last meaningfully reviewed. Here is where the abstract becomes specific, because the court filing is not built on statistics. It is built on names, and each name represents a moment where the system's stated purpose and its actual outcome diverged sharply. Carlos, Antonia, and Alejandro arrived together at the Fort Erie border crossing. Carlos had family already established in Canada. Under the family reunification provisions that remain in the system, he and his son Alejandro were accepted. Antonia, who was traveling with them but had no family connection in Canada that the system recognized, was not. She was returned to the United States. The family that arrived together at the border did not leave that border together. A provision designed to protect family unity, in this case, produced exactly the opposite outcome for the people it was supposedly built to protect. Marquez Apollon, a 25-year-old Haitian economics student, arrived at the Quebec border after the Trump administration moved to cancel the humanitarian visa program that had allowed many Haitians to remain in the United States legally. He had an aunt in Canada who could have supported his claim. At the moment his case was being processed, she happened to be out of the country dealing with an emergency. That timing, an aunt's temporary absence, became the basis for his deportation. He spent 4.5 months in an ICE detention facility in Buffalo before his case was resolved. Tenzin, a 29-year-old stateless Tibetan refugee who had fled Nepal, was turned away at the Canadian border entirely. He was placed in the same Buffalo ICE facility. While in custody, he suffered a stroke, specifically Bell's palsy, a condition affecting facial nerve function, and according to the court filing, he was kept shackled for days while medical staff attempted to treat him. Gurbir Singh was turned back at the border over a discrepancy in his fingerprint records, a documentation error rather than any substantive question about the validity of his claim. He was detained in Buffalo as well. It took his lawyer weeks of sustained legal effort to establish his identity conclusively enough to secure his entry into Canada, which finally happened at the end of April. 4 cases, 4 different countries of origin, 4 different specific administrative reasons for rejection, and in every case, the person did not simply fail to gain entry to Canada. They were transferred into a detention system on the other side of the border, a system whose conditions are now part of a federal court record in Canada because the lawyers representing these individuals argue that Canadian officials knew, or should have known, what awaited the people they were sending back. This is the distinction that the government's framing has consistently blurred, and it is the distinction this court case is asking a judge to formally examine. Closing a border to new arrivals is one kind of policy decision. It has consequences, it has costs, and reasonable people disagree about where the line should sit. But actively transferring a specific individual into another country's detention infrastructure when that individual has made a claim of persecution or risk that has not been substantively heard is a different kind of decision entirely. The first is border management. The second is a transfer of custody with direct legal and constitutional implications for the person being transferred. Because Canada's own charter protections do not simply evaporate at the moment a person is handed across a checkpoint. The drop in asylum claims that the government presents as a policy success is, in this light, a measurement with 2 possible explanations sitting inside the same number. Some portion of that 63% decline reflects people who never attempted to come because they understood the new barriers were prohibitive. But another portion of that decline, the the cases now before a federal court, reflects people who did attempt to come, who were processed through the exact administrative mechanisms Bill C-12 built, and who ended up not free, not home, and not heard, but in detention in another country's custody. A statistic that measures the volume of claims says nothing about the quality of the process those claims went through, and it says nothing at all about what happened to the people whose claims were rejected. Immigration Minister Lena Metleg-Diab's department released a new round of draft regulations on June 19th, continuing the same direction Bill C-12 established: faster processing, faster removal, tighter administrative control over who gets a hearing at all. The government's position, stated consistently, is that this is what a functional immigration system requires in an era of elevated global displacement and intense political pressure from a United States that has dramatically escalated its own deportation enforcement. There is a real policy argument behind that position, and it deserves to be stated fairly. An asylum system that takes years to process claims, that allows speculative or abusive applications to clog the queue for years while legitimate claimants wait, is also a system that fails the people it is meant to protect. Speed and procedural fairness are not automatically opposed to each other, but speed achieved by closing off humanitarian exceptions, by limiting access to legal counsel before a transfer decision is finalized, and by routing rejected claims directly into a foreign detention system without meaningfully assessing what conditions exist on the other side of that transfer, is not the same thing as a more efficient, fair process. It is a different policy with a different name attached to it, and the cases now in front of a federal judge are asking Canada to decide which one it has actually built. The standard has changed here in a way that deserves to be named directly. The Safe Third Country Agreement was built on a specific factual premise: that the United States provides asylum seekers a fair process and humane treatment, making it legally and constitutionally acceptable for Canada to return people there rather than hear their claims itself. That premise was last seriously tested in Canadian courts years ago, under a different American administration operating a meaningfully different detention and deportation system. The court filing now moving through the federal system is, at its core, an argument that the premise no longer matches the reality, and that Canada's continued reliance on the agreement, especially when combined with the procedural restrictions Bill C-12 introduced, has created a pipeline that delivers vulnerable people into circumstances Canada's own charter was designed to prevent. Watch what happens to this court case in the months ahead, because a ruling that the STCA's foundational premise no longer holds would not simply affect future claims. It would call into question the legal basis of every transfer that has already occurred under the current framework. And watch whether the government's June 19th regulatory proposals move forward without amendment. Because doing so, while a constitutional challenge citing 4 specific harm cases sits in federal court, would itself become part of the record this case is building. A number like 63% is comfortable to repeat in a press release. It requires nothing further to be said. The 4 names in the court filing require considerably more, because each one represents a moment where a system built to process volume met an individual person, and the volume is what the government measured, while the person is what the courts are now being asked to consider. If this story is telling you something you have not heard elsewhere, share it. Drop your thoughts in the comments. I want to hear it. Like the video if you want more of this, and I will see you in the next.